So data sharing is a very hot topic. There's lots going on in this area, and we've tried to condense it and crystallize it for you. Charlotte, if you move to the next slide, please. Yeah, so our agenda for this morning is going to be to take you through a little bit of the context of what we mean by data sharing, and the kind of commercial relationships in which it could arise, and just looking briefly at the regulatory framework, and the types of things that we expect to see in data sharing agreements of different kinds. And we will touch on the impact of Brexit. And then we thought it would be useful to bring this to life by looking at a couple of different types of scenarios, controller to processor type data sharing, and controller to controller data sharing, using these different examples for illustration. Next slide, please. So what is data sharing? I mean, here in this session, we're talking about the sharing of personal data. I think with this, we're looking at really no formal definition, but we do have a code of practice that's been issued by the UK Information Commissioner relating to data sharing and good practice. And what they describe data sharing as the disclosure of personal data by transmission, dissemination, or otherwise making it available. So making data accessible or viewable by someone else will constitute data sharing, even if there isn't an active transmission of that data from one party to another. So it is a pretty broad scope. And so you can see that in most agreements that relate to technology of some form, data sharing occurs, even if in a very minimal nature. In more complex scenarios, for example, business transfers, etc., there could be much more active data sharing going on relating to personal data. So we put this slide on here because when somebody mentions the word data sharing, there's just so much going on. There's just a lot of things to think about. So if we're sharing personal data, firstly, we've got to think, well, is the data personal data? Or is it not personal data? Is it purely anonymized, or is it personally identifying in some manner by one of the parties involved in the chain? If it is personal data, is it the type of personal data that benefits from enhanced protection, such as being special category data or criminal conviction or offences data? And this can be quite a nuanced question depending on the nature of the data sharing, particularly when you're sharing pseudonymized data sets, where there are IDs related to individuals rather than their names. What is the context of the data sharing in terms of what the parties are going to be doing with that data? And here we've got the concept of, are they, from a UK perspective or GDPR perspective, is one of the parties sharing the data the controller, and is the other party the processor, or are both controllers, or are they in fact what constitutes a joint controllership? And here, we really need to look at the decision-making role that that party has in relation to the data. Are they using that data for their own purposes, or are they using it purely for the purposes of the other party? And in this regard, the ICO has got quite useful checklists to help you work out whether you are a controller or a processor, because it can be difficult to tell depending on what you're doing. And we do find that in a lot of agreements that we're dealing with at the moment, there is a bit of a mix. between controller relationship and processor relationship. So sometimes within the same agreement, a party could be processing certain types of data on behalf of their customer, but using that same data set for their own purposes, meaning that could turn them into a controller in relation to some of the things that they do. So it's something that needs to be thought about quite carefully, depending on what the parties are doing. We know that the data protection laws provide a framework that has got to be complied with when the data is being shared with another party, when you are appointing a processor or a sub-processor. There are mandatory provisions that have to go into that agreement. So that is something that we also need to pick out in terms of appointment of a sub-processor. We then need to look at international data transfers, and we'll touch on that in a little bit more detail later, although we have done another webinar on that topic because it's quite a topic on its own, so we can make that available to anyone if of interest. But onward data sharing has got to think about whether mandatory processing provisions need to be included, whether any international data transfers are occurring, and if so, what safeguards apply and what needs to be done on top of that. In addition to that, there are various other factors that you need to think about. Statutory compliance. We've got the record keeping obligations that are provided for under the data protection regime, which need to be thought of. And if there is artificial intelligence that is being deployed as part of the data sharing, we need to think about ethical factors that are involved in the use of the data. Is it appropriate? So there's just a lot going on when you're trying to achieve your regulatory compliance. And I think the ICO's Code of Practice does help pick out some very pertinent points relating to data sharing, but we thought this might be a useful high-level picture of the different factors that need to be considered. I mentioned EDPB guidance there as well. EDPB guidance, European Data Protection Board guidance, that is, post-Brexit. Not directly applicable to the UK, but obviously still extremely persuasive and relevant. And one of the things that we do find cropping up for our clients is the extraterritorial nature of these data protection laws. To what extent are the parties involved in data sharing captured by these laws, even if they might be outside the UK or the EU, so it's useful to consider territorial guidance that might apply, as well as other types of guidance on anonymization that could be relevant when data sharing. Next slide, please. So the ICO's data sharing code has been issued with the purpose of giving individuals, businesses, and organizations the confidence to share data in the fair, safe, and transparent way. And really, I think from a UK regulator perspective, they do not want data protection laws to impede genuine, legitimate, fair, safe, and transparent data sharing. They want to ensure that if it is appropriate to share data, that organizations feel confident to be able to share data while ensuring that all relevant safeguards are in place. So that really is the approach of the UK regulator in trying to ensure that data sharing can proceed in an appropriate way. So types of data sharing, we talked about how it could occur in different contexts. One-way or reciprocal exchange of data between organizations. There could also be data sharing in the context of collaborations. Research and development. We see this occurring with in the life sciences sector, for example, with clinical trials, the number of different parties involved, and data is shared using very sophisticated anonymization and pseudonymization techniques often. But analysis has to occur at each part of the chain. There could be routine, systematic data sharing for particular purposes, such as being able to operate across a group of companies, which is a very typical way of data sharing. It could be structural, or it could be an ad hoc situation. For example, if you are about to conclude an acquisition, and you are about to receive the database of the target company, how should that occur? When should that occur? And what safeguards need to be put in place when that occurs? So these are different examples of when the data sharing code can be relevant to help you navigate your way through those different factors that we mentioned. So looking at the types of relationships again, and I picked up on this point earlier, what are the roles of the parties? And, these are some very typical roles. And I think when you are working through a data sharing agreement, firstly, once you've worked out what kind of data is being shared, you can then assess the role that each party has when they are sharing the data. And we've set that out really here to just help you visualize what might be relevant in that data sharing, also bearing in mind that it could be a mix. So what are the relevant principles that you need to think about when you are data sharing? One of the things, there is the agreement itself that we need to think about between the parties, but there are also things that we might need to consider, we do need to consider outside the agreement itself. Firstly, how do we satisfy the overarching requirement of having a lawful basis for what we are doing with that personal data? What is that lawful basis? And what is that lawful basis relating to the type of data that is being shared, whether it is personal or special category, etc. If we are relying on legitimate interests, the UK regulator recommends a legitimate interests impact assessment to ensure that we can genuinely rely on this lawful basis in order to share that data. Legitimate interests, as you might recall, requires there to be an identifiable interests to be addressed. And what you will be doing, as in here, the sharing of that data must be necessary in order to achieve that interest. And this must be balanced against the rights and freedoms of the individual. And often when we think about using legitimate interests in the context of data sharing, it is the balance that we need to focus on. How are we addressing the rights and freedoms of relevant individuals? And I think the most important factors here will be, have we thought about data minimization? Do we actually need to share the data in a personally identifiable form? What about the timing of the data sharing? Are we sharing data too early? For example, in a transaction, do you need to put personal data in a data room in that form? Probably not. You need to phase the way in which you share data in order to make sure that the balance is correct and data is not overly exposed to risk. If you are engaging in controller-to-controller data sharing, as in each party has got its own purposes in relation to the data and will be using the data independently for those purposes, or potentially jointly, the parties need to think about how this is communicated to the data subjects. So you might, just as a recap, there are specific requirements under the GDPR that that information is given to individuals about what controllers do with that information. These requirements differ when you are receiving the data from the data subjects directly, or when you're receiving the data about that data subjects from another source. So, for example, through data sharing. And so the privacy notices that are given to these data subjects have got to be checked to make sure that each party's requirements are addressed, and that it might be that the parties, when they are setting up the relationship, will commercially agree the form of a privacy notice that meets the requirements of both parties to minimize the notices that are given to the individuals and to increase the transparency of what is happening, so that individuals are more easily able to understand it. Accountability. Now, we've got some excellent guidance in the UK about the accountability framework and governance. And I think, when you're looking at data sharing, you have to look at it in the context of your overall accountability framework. Now, do we need to carry out a data protection impact assessment for the kind of data sharing that might occur? And there are forms and templates available on the regulator website for that. We'll look at, what you put into the data sharing agreement, and Dan will touch on those things. And then your record keeping obligations, those will need to be updated to ensure that the data sharing activity is captured. So data minimization, data accuracy, data retention, and then integrity and confidentiality. These are some key things to think about in relation to, how you structure your data sharing agreement. How will you be complying with all of these obligations in relation to the data sharing? And do your policies and procedures, your data retention policy, for example, need to be updated to take into account the data sharing that is going to occur. I think integrity and confidentiality is something that does need to be addressed in contracts in terms of the parties' obligations, and ensuring that appropriate obligations are placed on both parties to ensure the confidentiality of the data and the purposes for which it is going to be used, because this has got to be in line with purposes that are communicated to the data subject. So it's all linked, and that's why it's important to have that overarching picture of all of the different types of things to think about that we raised at the beginning. So data sharing agreements are recommended by the ICO's Code of Practice, and they will typically contain, controller-to-controller obligations or controller-to-controller processor obligations relating to, the purposes of the data, how data is going to be treated when it is shared, and there will be provisions needed to, as I mentioned, to address communications to data subjects, and also how to engage with the other party if individuals exercise their rights under these regulations. Will the parties have to collaborate in order to ensure that these rights are adequately dealt with? What happens if there is a breach? Will the parties have to report it to one another? Those sorts of things. And then typical contractual provisions around liabilities, indemnities, confidentiality will need to be addressed, and where data sets are being created. So, for example, if there is a original set of personal data, it is being anonymized by a processor. There's a set of aggregated statistical data that is being created as a result of that. Who owns the intellectual property that might reside, if any, in the resulting products? So these are the sorts of things to consider. And again, if you are carrying out an impact assessment, you need to keep it under regular review in case things change, in case the regulatory picture changes as well. So just a note on Brexit, and also I think within this I'll mention international data transfers. The UK is now a third country from an EU perspective. Data transfers between the UK and the EU are generally able to occur freely, aside from some particular requirements that will apply in relation to transfers for the purposes of immigration control, where further insight might be needed. But aside from that, we're generally free in relation to data movement between the UK and the EU. And the UK has adopted the approach that exists under the GDPR in relation to international data transfers. So in brief, and I mentioned there is another webinar available on this topic, in brief, when the data is transferred outside the EEA, the UK adopts, there's a list of safe countries. There are safeguards that need to be applied when you're transferring the data to countries other than those, such as the US. There is a lot of moving parts relating to the use of standard contractual clauses, whereby we have a current situation that the UK has published new standard contractual clauses that need to apply for transfers of data that are subject to the EU GDPR, and the old EU standard contractual clauses are still a valid mechanism for UK transfers. So, so it's all a little bit messy at the moment, but we're expecting that things will be tidied up in the new year when the UK updates its own version of standard contractual clauses. So quite a bit going on where there is any international data transfer that needs standard contractual clauses. Again, there is some guidance on the ICO's website on this. One further thing to mention here is that due to case law, standard contractual clauses alone are not going to be sufficient without a further transfer impact assessment and the addition of supplementary measures if needed. And we'll be happy to talk a little bit more about this separately if of interest. So now over to you, Dan, because I think we're going to try and contextualize things for you.
Thanks, Jo. Right, so I'm going to walk us through a couple of scenarios around data sharing. So the first scenario that I'd like to talk about is the appointment of an IT supplier. So generally speaking, what we'd expect to see is the customer acting as the controller in this situation and the supplier acting as the processor. And when we're talking about IT suppliers, we're talking about the kind of off-the-shelf IT products that you might get, CRM providers, hosting providers, that type of service. Initially, we're going to look at this from the customer controller's point of view, and then we're going to flip it around and look at it from the supplier's point of view. Next slide. So initially, we need to look at what is the purpose of sharing and how is that data processed. Purpose is fairly straightforward. I need to manage my CRM data, I will find a CRM provider. It's kind of that simple. But then you need to go a step further. What data does that CRM provider need in order to achieve that purpose? Is any of that data perhaps extraneous, or perhaps they don't need it? If so, you'll need to look into that. And then another step forward is understanding how that IT supplier processes that personal data to achieve the purpose. For example, with a CRM provider, they might just be hosting that data in kind of a grand Excel sheet, so to speak. But if they're doing other things like profiling, tracking users, or other things, that is a very different act of processing personal data, and that would need to be investigated for compliance. As well as a customer, you need to make sure that your privacy policy is correct. So really what we're looking for is the act of processing adequately transparent on the privacy policy? Do I have a lawful basis for it? If it's consent, do I have the necessary consent for processing? Is the privacy policy transparent about the fact that I'm going to share the personal data with this new IT supplier? And of course, if the IT supplier is outside the UK, setting out what international transfer mechanism is used to safeguard the data, be it adequacy decision or standard contractual clauses or something else. Very importantly, controllers must only use processes providing sufficient guarantees to ensure the security and rights of data subjects. In brief, controllers should not appoint processors who they know cannot protect the data. So these guarantees must be demonstrable. So this might actually require the exchange of documents between the customer and the supplier. So they may be looking at terms of service, records of processing, information security policies and audits. Perhaps the supplier has signed up to some recognized certifications for security. This is very much a form of risk assessment by the controller, which will be made on a case-by-case basis. But in doing so, they can take into account the supplier's knowledge and expertise, their resources and their reliability. Have they been subject to a data breach in the past? Have they been subject to an investigation in the past? All of those you need to work through. So more and more what we're finding is, especially larger customers are creating a checklist that they will run through whenever they appoint a new IT supplier. It's become almost standard procurement procedure for some entities. And that might also include a questionnaire, which is then sent to the IT supplier to complete. Next slide, please. Okay, so now we turn to the data sharing agreement, or the terms, just to say, you don't need a separate data sharing agreement. It can be termed within an existing supply contract, but you must have a binding agreement in writing with a processor that contains the mandatory processing terms. This is not an optional thing. You've got to have it to be in compliance. I'm not going to run through all the mandatory processing terms of Article 28 here, but what I do want to do is say that you shouldn't merely restate these provisions of the GDPR. You need to be looking at the obligations, looking at the processing and kind of marrying the two together. For example, an important issue for the customer could be responding to data rights requests. For example, our CRM system, big platform, lots of personal data. If an individual sends a subject access request, then we as the customer need to go to our IT supplier and gather up that data for that access request. If our CRM provider then turns around and goes, well, we don't really have that capability, that's going to take a couple of weeks, it's going to be very expensive, that's not a situation that you want to be in. So you want to be having those conversations initially and figuring out how to deal with rights requests and similarly breach if it were to occur. And then as well, another one just to touch on is audits. You may have a platform that you want to audit frequently or infrequently, dependent on the processing and the personal data combined. The audit should be set out more fully. So you're looking at what is the notice period for conducting an audit? What is the frequency? Can I do it more than once a year? Who is involved in an audit? Perhaps the customer can appoint a third-party auditor, or can the processor carry out some of the audit? All of those things need to be considered. And then moving on to liability. Thank you. Moving on to liability for processors, a controller is primarily responsible for its own compliance and ensuring the compliance of its processor. And basically what this means is regardless of the terms of the contract with the processor, the controller could be subject to the corrective actions and sanctions for a data protection breach of the processor. You may also get a situation where an individual can make a claim against the controller or the processor for a breach. So you'll need to look at liability very closely in relation to making sure that you as a customer are protected. More and more what we're seeing is a separate liability cap for data protection breaches. And if possible, a lot of customers are pushing for indemnities in relation to data protection breaches. And just to touch on it, Joe said this again, but looking at international transfers of personal data, if our supplier is outside the UK or they're in the EEA, that can be okay because we've got an adequacy decision. But if they are, for example, in the US, then we need to put a transfer mechanism in, and that could be standard contractual clauses and then the matching transfer impact assessment. Next slide, please. Okay, now we're flipping it around. We're looking at it from the suppliers, the processors perspective. The first thing is be prepared for data protection questionnaires. More and more we're seeing this of suppliers being sent questionnaires to complete where they're asked, who are your sub-processors, where do you keep the data, who has access, things like that, that you'll need to be prepared to evidence to potential customers. The next point to talk about is what are the controller's documented instructions. Processors may only process personal data of the controller on their documented instructions. There's a couple of exemptions in relation to applicability of law. But of course, if you're the processor, you need to be figuring out what are the documented instructions, and they can be contained in our data sharing agreement, or possibly they could be in other forms of communication. If they're an email, do I need to keep those emails? If it's a phone call, how do I record that? European guidance does recommend that processors store records of documented processing instructions just in case they're questioned at a later date. The next up is sub-processors, always a key issue for an IT supplier. Nobody works alone these days, so your IT supplier is going to have its own IT infrastructure that it will engage in order to provide the service to the customer. So the first question is appointment. Controllers must give consent to the appointment of sub-processors. So we do this in one of two ways. The first is general, where we provide a list to the controller, and if that list changes, we let them know, and then it's the controller's choice of whether they want to object or not. And the other way is specific, where each new appointment needs the consent of the controller. There's actually quite a big difference, because specific, you are requiring the controller to take action in every step. You need their consent in order to appoint that sub-processor. As general, you're only waiting to see if the controller objects to it, so you can set timeframes around it. Of course, gathering specific consent is going to get very problematic if you've got 1,000 customers and you need all of them to give consent to a new sub-processor. If you're a larger entity with thousands upon thousands of customers, you may take the approach of take it or leave it. Here, we're updating our processors. If you don't like it, then you can terminate. But not everybody can take that path. So you may take an option where if a controller does object, then they can set out their objections in writing and give the supplier a chance to satisfy those objections. And if they can overcome them, then the sub-processor can be appointed. The next point to talk about is terms between our IT supplier and its own sub-processors. Sub-processors must be engaged by imposing the same data protection obligations as imposed on the original processor, our IT supplier. So the same doesn't mean the same word. What we're looking at is the same obligations, which is much better, but still can lead to some problematic issues. For example, we may be in a small IT supplier and our customer has a lot of negotiating power and want very burdensome data protection terms, but our existing IT sub-processors, our supply network, they might be very large IT suppliers with standard terms, and we, as the kind of piggy in the middle, can't really negotiate those terms. So you'll find in that type of situation, what you'll be doing is saying to your potential customer, well, okay, we could look at these, but I would need to almost create brand new contracts with my entire sub-processor network, and that would create incredible cost and delay, and quite frankly, could be completely unfeasible. The last point to talk about in sub-processors is onward personal data flows. So again, controller's documented instructions includes about onward transfer to third countries. So you can put clauses in the contract of how consent might be obtained. Another way to do it is when you are setting out who your sub-processors are and getting consent, if you can set out the jurisdiction where they are. So the controller consents to both the sub-processor and the jurisdiction at once. The final point on this slide to talk about is what happens on breach of the agreement. Occasionally we have seen that customers will ask for termination rights for a breach of data protection obligations, which I'd get nervous about because there may be very minor breaches of the agreement related to data protection. As well, you've got to remember that your customer controller has certain rights of audit. So you may have a customer who really wants to get out of this agreement and they have an audit right and they have a termination right that arises due to minor breaches. So that's just something to look out for in the drafting of the agreement. Next slide, please. Okay, so the second scenario we're going to talk about, this is controller to controller sharing. So this is about a recruitment agency here. So on one side, you've got the recruiter who is going out to the market trying to find candidates, and then the employer who is trying to hopefully find a suitable candidate to employ. So the starting point with controller to controller, it's good to think about who holds what personal data initially and why are they sharing it. For example, our recruiter will hold certain candidate data, they'll hold the CV and the contact details, and then they will provide that to the employer. But the employer might then generate new personal data, for example, interview feedback, things like that. If they want to hire the candidate, it might be personal data created, and they might send that data back to the recruiter. Now, as well as candidate data, there might be other personal data involved in this type. So the recruiter and the employer's employees, the people kind of managing the relationship between these two entities. Of course, that personal data sharing is going to be much smaller, company emails, things like that, but it's still an important thing to recognize that you are transferring that data. Next slide, please. Okay, so initially we're looking at what is the purpose of sharing and how is this data processed. It's very similar to when we were looking at appointing our IT supplier, but in a way it becomes even more important because when we're appointing a processor, they only process on our documented instructions. However, controllers aren't subject to that. So what you're looking at is if I am passing this candidate CV and this candidate contact details to this employer, what are they going to do with it? What do I want them to do with it? Should I put any restrictions in place? Things like that need to be considered. As well, you might have standardized ways of dealing with personal data for an organization. For example, our employer might have an employment portal whereby all CVs are submitted to this portal. The reason they've done that is it's a way to make sure that CVs are not found in random inboxes and that they can ensure that data retention and deletion is adhered to. So if that's the case, thinking, okay, I've got this method, this process for dealing with this type of personal data, this recruiter, can I fit them into that existing procedure and letting them know? And then you may get to a point where a data protection impact assessment is necessary if the processing is likely to result to high risk to freedoms. Even if you don't hit this bar, sometimes you might want to carry out an impact assessment in any event, especially if the data is a bit complex and you really want to understand it. It's kind of a good thing to do. Looking at the privacy policy now, again, we need to look at, has the processing activity been transparently set out on the privacy policy? Do I have a lawful basis? Can it be shared? Things like that. But then you've got to flip it around and think, okay, what personal data do I expect to receive from this other controller? So as the employer, you're maybe expecting to receive candidate data in the form of CVs, contact details, that type of thing. So you'll want to make sure that the employer's privacy policy also covers that kind of expected receipt of personal data. Okay, and now we go to the data sharing agreement. There's lots to consider in a data sharing agreement. And of course, this can be applicable to other controller-to-controller relationships, but we'll just walk through it in relation to our recruitment agency scenario. So the first thing is, what personal data will be shared and why? Much like you'd fill out a service agreement with the details of the service provider, we need to understand what personal data is being shared between these entities and why. And then this links into how personal data may be used. There's definitely data protection considerations here. For example, the recruiter may not want the employer publishing candidate CVs or data, or even providing them to perhaps other recruitment agents or its competitors. So as well as data protection, you can also think of the commercial considerations at play. Is that personal data a form of know-how or an IP or something like that that would need to be protected, not just because of personal data considerations? Privacy notices and consents. So we've talked about updating and making sure that your privacy notice is up to date, but now we need to figure out how do we provide our privacy notice to the data subjects. So for our recruitment scenario, it may actually make sense for the recruiter to provide the privacy notice of the employer, because the recruiter has a direct relationship with the candidate. So that might make sense and might make it easier to do so, in which case you might want to set that out in the data sharing agreement. Equally, if consent is needed to process personal data as a lawful basis, who is going to collect that consent and what is the language of that consent can be very important. For example, if our recruiter is collecting consent from the candidate on behalf of the employer will really need to make sure that the consent capture is valid and that it's happy with the language being used, and as well, perhaps get a record of that consent being captured in case it is ever questioned in the future by a regulator. Confidentiality and security, kind of what you'd expect. We want to make sure that the personal data is protected. So this might be making sure that individuals who have access are employees of the recruiter or of the employer are appropriately bound by confidentiality requirements, and as well making sure that we've got security processes in place. So for our employer, if they do have kind of a portal which they hold recruitment data in, making sure that the recruiter uses that portal in the correct manner will be important. The next thing to think about is assistance with data protection obligations. Do the parties need to help each other if there is a data protection impact assessment needed, or if a data breach happens, or if there's a rights request? Do the parties need to help each other out? For example, if consent is used as a lawful basis and the candidate contacts the recruiter to withdraw consent, how does that then impact the employer's processing of that data? And that needs to all be mapped out within the contract. And then the last point to mention is reviewing the data sharing agreement. I think it's fair to say that data protection law is a fast moving area of the law which is rapidly changing, especially in relation to international data transfers. We're expecting further large changes next year into it. So regular review is a good idea just because the law might change. The other thing to say is the relationship between the parties might change as well. Be it over months or years, you can have relationships which evolve and morph, and the data sharing may change or get much grander than was initially envisaged. And because of that increased processing, you may look at your data sharing agreement and go, okay, well, now we need further assistance with the data protection impact assessment, or actually I would like the privacy notices provided in this way to this data subject. So that's another good reason to keep reviewing your data sharing agreements.